The Muslim marriage and the common law. Over time, and as we know, there has been a public social distaste. 46% of Canadians have a disfavorable view of Islam, and 56% of Canadians believe that Islam suppresses women's rights, according to a survey done in 2020. With this kind of perception, it's no wonder that courts and the economic world have all been influenced one way or another, from the public sector to even the private lives. And for people who see religion central to their lives, you cannot be asking them to leave religion out of it or check God at the door. Quote by American psychiatrist Dr. Rania Awad. She is right in this, and although she may not be talking about marriage, marriage also applies. The resolution of matters through Sharia law remains equally important for converts and Muslim-borns. Thankfully, Islamic law is slowly being introduced and diversified in the evolving world of law and jurisprudence, especially when it comes to validating or nullifying a pairing. Before understanding the economic nuances, we first need to understand what is an Islamic marriage. What are the implications when it comes to secular common law? And how can the situation be improved? A common misconception is the idea that North American Muslims wish to establish Sharia laws as this alternate legal system. Well, that's simply not true. In truth, they only wish to be protected and respected under the common law of the land. Not to reform, but to compromise and to be taken care of. So, what is exactly a Muslim marriage, or Islamic marriage, or the word Nikkah? From the legal point of view, is just a contract between two people. Without Nikkah, it is impermissible for man and woman to be together. The elements of a Nikkah includes an offer and an acceptance, witnesses, Mahr or bridal gift, and additional terms. And while an oral contract of marriage is sufficient in Sharia, common law jurisdictions require registration for the validity of marriage. Originally, the reason for this is 1400 years ago, most of the places in Arabia where Islam came down to, people were illiterate, so they used oral contracts and ceremonies to publicize and solemnize a marriage. In today's world, we live in a world that's so big, so many people across the globe, it is really hard to keep track of who is married and who isn't. Hence why papers are needed to legally prove or justify marriage in case where it needs to be proven. The Mahr is known as a bridal gift, and it must be paid from the man to the woman, from the groom to the bride. But this is not a bride price, but a marital financial investment. The Mahr can be composed of two parts: advanced payment, right before the marriage, and a delayed payment, right after the marriage. The thing with a delayed payment is they can set it for as long as need be. It could be immediately after, a few months after, or whenever they can pay it off in their lifetime. This is given by the groom to the bride and can be any amount that the bride is willing to accept. It does not have to be monetary in value. It can be something as simple as a date or a plane ticket. Quite frequently, there has been a trend of wives asking their husbands for cats as Mahr. A pet cat can even be Mahr. So what it is essentially is a bridal gift given in good faith, but in the original traditional context, it's usually monetary value. For the sake of keeping it simple in this presentation, we will be talking about Mahr as a financial aspect. And since this is the property of the wife, she has full right to how it's being spent. She is not obliged to spend it over household expenses, not on furniture, not on childcare. The husband is required to spend upon her and the household. This feministic and equitable method ensures that the wife is not in lack in case that the marriage terminates, so that she has a little bit of backup the man leaves. In cases where pregnancy or separation, it's always the woman that loses more. The Mahr is to equalize and provide a woman with a safety net. According to Muslims, Mahr is not a cultural thing but actually a religious obligation, as ordained in the Holy Quran, which says, "Give the women upon marriage their bridal gifts graciously, but if they give up willingly to you, then take it in satisfaction and ease," meaning that the woman gets the right to say and what she wants, but if she changes her mind to make it easier on the groom, it is her right to, then that should be the case. It has been noted that this marital consideration on behalf of spousal equity, which doubles as a safeguard against oral divorce, as in the man can't just pick up his bags and leave if he spends a large sum of his life earnings on the Mahr, finds no parallel in any other legal system. So we know that a man is serious when he invests a lot in his wife. And then we know he is not likely to simply demand an oral divorce or to simply leave because of how much effort he's been putting into this marriage, so that we know, for one, the man is serious, and we know that for two, the woman will be safe. That is the purpose of the Mahr. Ontario Section 31 of the Marriage Act says, in order to comply with the Marriage Act, the reasons are fairly simple. These are the reasons below: in which a marriage is considered legitimate, the marriage is solemnized in good faith, there was an intention to comply, neither party was under legal disqualification, and the parties lived together or cohabited. The fourth one cannot apply to Muslim couples, as Muslim couples cannot live together before marriage. In one Canadian case, a couple conducted an Islamic wedding under Sharia law, but during the ceremony, the marriage license has not been issued, nor were they registered. However, the Ontario court deemed it valid due to it following number 2. There was an intention to comply, so the court accepted their marriage, despite the fact that they did not have the civil marriage license. But overall, there's this misunderstanding of Mahr, because what happens to this bridal gift during divorce? Should it be split up, even though it's supposed to be a safety net for the woman? That's happened before. And this is due to the North American context. The Mahr is often quite confused, and it is also the most common family law issue considered by the courts. The most common observation made is that courts are often inconsistent in how they deal with Mahr, or bridal gift. In an English case, a wife sought out decree of divorce on the basis that they had been married in Damascus in 1996, but the husband argued, "We were never married." The wife wanted to leave, to divorce, through the secular court, to gain her rights, but she couldn't divorce since she could not prove her marriage. The judge concluded, "It is inappropriate for me to try to determine an issue, because in the husband's subjective opinion, there does exist a status of religious agreement that falls short of marriage," meaning that the husband said, "We weren't actually married, despite being Islamically married." The wife did not have the English court's protection. Once a Muslim woman and a non-Muslim man entered a mut'a, which is like a Nikkah, but a mut'a is a temporary Nikkah, temporary marriage, in 1982. 2 years later, the husband legally married another woman, and the first wife filed for her divorce. However, she was unfamiliar with the U.S. laws. The California Court of Appeals found her belief to be unreasonable, as her marriage was privately solemnized, unlicensed, and unrecorded. Therefore, there was no legally recognizable marriage. As a result, despite being Islamically married, the wife did not have the English court's protection. She could not prove that she was married. And as her husband took in a second wife, it was legal for the husband to do this because the first wife was not registered and the second one was. The first one was Islamically registered, but the second one was legally registered. And of course, the courts will obviously give more weight to the legal marriage, and this causes a problem for the woman as she is now stuck in a limping marriage, which will be discussed later. There has been another case where Mahr has been dismissed, as the father of the intended bride, he set the figure to be $35,000 and would not accept any less. He said that Sam, the intended groom, and his father agreed upon the $35,000 Mahr, and all agreed that $5,000 would be paid before the marriage and $30,000 would be paid later throughout time. Remember that we have discussed that a deferred Mahr is acceptable, but it must be paid. Sam did pay $5,000, but when divorcing, he refused to pay his promise of the deferred $30,000. This is quite regrettable for both of them, since Manira and Sam were both young. They were in their early 20s, just graduated high school, and there was no way, realistically, that Sam would be able to pay $30,000 without a stable employment. However, this was expected that Sam would pay throughout his lifetime, even in the case of divorce. It may have been a bad idea for Manira's father to demand this much for his daughter. It was also a bad idea for Sam to Islamically accept the $30,000 Mahr when he knew he could not be able to pay it. The court held, to the extent which it obligates a husband to make a payment to his wife is essentially and fundamentally a religious matter. Because Mahr is a religious matter, the resolution and dispute relating to it are also religious in context, meaning since it's a religious issue, we're not going to deal with it. Us, the court, we will refuse to deal with it. So taking the secular approach deprived the woman of her religious rights, and arguably her charter rights to manifest her religion. And now let's discuss limping marriages. The existence of a limping marriage occurs where the marriage has ended but the woman cannot remarry because she is still religiously married. It's possible for men to be in limping marriages, but the case is quite rare, so for the sake of this presentation we will discuss mainly about women, where when the woman is religiously married but not legally married, or when they're legally married but not religiously married, there appears to be a limping marriage. And what this means is if there is ever any grounds for divorce, there is kind of an issue, because in one sector they're considered never married to begin with, but on the other sector it seems like they were. A 2001 report in Australia found for those who find themselves caught between these two discrete legal systems, it is a heavy nuance, as the consequences of being divorced under the rules of one system and not being able to be divorced under another can be emotionally, financially, and spiritually debilitating. Going forward, how can we fix these issues of dismissed mahr, or how can we fix these gaps between two systems that are pretty much mutually harmonious? Between Sharia law and the common law, there are many overlaps, as Muslims do not wish to replace common law with Sharia law, but they do wish to be accommodated for. What the courts can do in the future is research and empathize by surveying, reading, and interviewing both normal Muslims and professional imams and religious spiritual leaders. They can also have an open discussion of the topic for the Muslim community to chip in and see what they want. They can also adapt, as mistakes are bound to happen, but the good thing with law is that it's mutable in nature. It can be changed if the public demands it. We can learn as time goes on how to create a more equitable marriage sphere so that couples can get married and divorced as they wish.